please, your lordships. I was going to go on to look at the case law to show your lordships that the type of factors that have been considered by the courts in this context have been the type of factors that we've been describing as objective and have not included the type of factors which ended up being decisive in this case. Can I please start with the case of Guzzardi, which is in Volume 3, tab 24. And if I can start on page 342 at paragraph 21. Paragraph 21, just dealing with the chronology, you'll see there it's recorded that after a period of time...
I'm so sorry, what page are we looking at?
Sorry, it's page 342.
Thank you.
Paragraph 21, recording the transfer in July 1976 to Forche on the mainland from the island of Asinara, which had been the subject matter of this application. And as I've already mentioned, a similar application was made in respect of Mr. Guzzardi's stay in Forche, but the Commission rejected that as inadmissible, even though all the conditions were the same other than the location of the actual residence, as you see from the last part of paragraph 21 there. The description of Asinara starts at paragraph 23. I know this is familiar to a number of your lordships, and I won't read it all out, but the description of the locality there, all objective matters. On page 343, possibilities of movement, and that's also describing matters which affect anybody staying on Asinara, anybody subject to compulsory residence in Asinara, and where they could go and who they could associate with. Under heading 3 on page 343, description of the accommodation available, again, applicable to anybody in compulsory residence. Under heading 4, page 344, medical assistance, health and sanitary conditions. And then under 5, presence of the family. Perhaps I can draw attention to this. Persons in compulsory residence could apply to the administrative authority for permission to have their nearest relations join them on the island and stay with them either in the pagodina, which is one of the buildings, or failing that in the rather confined bedroom allocated to each of them. The government stressed that the shortage of water on Asinara made it necessary to limit the number of persons authorised to stay there. Initially, the applicant's wife and son, and also from time to time his parents-in-law and a nephew, lived together with him. On 9th of October 1975, that's about 8 months after he had been sent to Asinara, members of this family were ordered to leave the island. Their residence permit had expired on the 18th of August. He had not applied for their renewal. They were, however, able to return at the beginning of December and stayed with him until his departure for Forche. So it was 8 months with his family, about 2 months without them, and then about 7.5 months with them. And then, if I can please go on to paragraph 91, which is on page 362. The government's submissions are set out in paragraph 91, disputing the correctness of the Commission's analysis. And the government submissions pointed to a number of matters. You see the distinguishing characteristics of freedom was less the amount of space available and so on. And then about a dozen lines down, you'll see the government specifically mentioned that his wife and son lived with him for 14 of the some 16 months he spent on Asinara. The inviolability of his home and of the intimacy of his family life, 2 rights that the Convention guaranteed solely to free people, were respected. Even as regards his social relations, he was treated much more favourably than someone in penal detention, and so on. And then at 92 is where the court's decision actually starts. It has the familiar paragraph about Article 5 proclaiming the right to liberty and contemplating physical liberty, and not concerned with mere restrictions on liberty of movement. And then concrete situation and account being taken of a whole range of criteria, such as type, duration, effect, and manner of implementation. 93 is the paragraph that deals with difference of degree or intensity. 94 is a mention again of the inadmissible application in relation to force. And then the court says it does not follow that deprivation of liberty may never result from the manner of implementation, and in the present case, the manner of implementation is the sole issue that falls to be considered. The government's reasoning is not without weight. It demonstrates very clearly the extent of the difference between the applicant's treatment on Asinara and classic detention in prison or strict arrest imposed on a serviceman. Deprivation of liberty may, however, take on numerous other forms. Their variety is increased by developments in legal standards and attitudes, and the Convention is to be interpreted in light of the notions currently prevailing in democratic states. And then the court goes on to list the factors which it thinks were the decisive factors in this case. First of all, the area around which the applicant was able to move, which far exceeded the dimensions of a cell, but covered no more than a tiny fraction of an island to which access was difficult, and about 9/10 of which was occupied by prison. The next one was housing. Mr. Kutsari was housed in part of the hamlet of Cala Reale, which consisted mainly of the buildings of a former medical establishment which were in a state of disrepair or even dilapidation, Carabinieri Station, school and chapel. The next point is who else was there, lived there principally in the company of other persons subjected to the same measure and of policemen. Permanent population of Asinara resided almost entirely at Cala d'Oliva, which Mr. Kutsari could not visit and would appear to have made hardly any use of its right to go to Cala Reale. Consequently, there were few opportunities for social contacts available to the applicant other than with his near family, his fellow residents and the supervisory staff. Supervision is carried out strictly and on an almost constant basis, and then refers to the curfew, reporting to the authorities twice a day, requiring consent for trips off the island, and liable to punishment by arrest if he failed to comply with any of his obligations. And what we respectfully point to is the fact that none of these factors which the court relied on in concluding that he had been deprived of his liberty on Asinara, but not Force, related to the presence or absence from time to time of members of his family, his wife and son, and you'll recall from the previous paragraph also some more distant relatives at times as well. Simply does not feature in the court's reasoning in this paragraph, where it lists the factors which it thinks are the objective factors to be taken into account in deciding whether or not there was a deprivation of liberty.
Well, except that it had regard to the fact that he was with his near family, which was presumably a pointer against the conclusion that they were reaching.
They did refer to the fact that he was with his near family, but they weren't there all the time, because there was a period of 2 months when they were not there, when none of them was there. But
that was when
35. Paragraph 35.
He hadn't applied to renew their residence permit, had he?
That's right. And so they were absent for a period of time, but then they did obviously ask to come back and came back. That was, there was the period...
they were there for 14 out of 16 months, that's what the government says, and they were right.
Well, the government were right, but if his presence or absence of his family had been an important factor in the court's decision as to whether or not Mr. Kutsari had been deprived of his liberty, one would have expected to have seen something.
Well, it was a relevant factor in deciding whether or not he was deprived of his liberty. Otherwise, they wouldn't have referred to it at the top of page 364. Actually, on the facts, it was a pointer the other way.
95 is a list of the factors pointing to deprivation, not of those which might compensate.
Well,
Apart from
looking at a number of
there
factors
was
which might have...
there's an Article 8 claim which failed on the merits, as it were, not under Chapter 2 at paragraph 109.
Indeed, there was an Article 8 claim as well, but this reasoning is all relating to the question of whether or not there is a deprivation of liberty. And looking at the particular factors on
If there was no interference with family life, interference with family life couldn't be part of the picture of deprivation of liberty.
The list of the factors,
yes.
which is at the beginning of the next paragraph, isn't it? On the strength of any one of these factors taken individually. It's listing the negative factors.
The point that we make is that if a factor such as the family being with him or not being with him as a matter of choice, because they'd obviously chosen to come back to Asinara after having been removed from there, one would have expected to see some reference to the difference in quality at the different times when the family weren't there and then when they had come back again. But we don't actually see that. All there is the one compendious reference to social contact available with his near family, his fellow residents and the supervisory staff. And that...
But at the bottom of page 363, there were few opportunities for social contact available to the applicant other than with his near family.
That's right.
And it would have been a stronger case in his favour if his near family had not been there.
Yes. It's a compendious reference, and it does not appear to deal with the difference in quality caused by his family's absence and then their reappearance on the island. And that, we respectfully say, is an indicator.
So, one indicator that they didn't think that the fact that they chose to leave was relevant.
What they are looking at is objective opportunities, given the situation on Asinara, for social contact to be available. They're looking at a package as a package, and not at what individuals were choosing to do at different times during the chronology.
I mean, he couldn't make much of it because, I mean, as I understand, they failed to apply for a new permit. That was the reason they were shipped out. Then they came back.
Yes. They came back. They obviously having been shipped out, they obviously wanted to come back and came back. Okay. And if the fact that they had chosen to come back and came back was a factor which would have lessened the likelihood of a deprivation of liberty, we respectfully say that one would expect to see something in this about that. But instead, the tenor of this paragraph is all about looking at the package as a whole, objectively looking at the package as a whole. What happens if you are an individual who's been sent here to live on Asinara, given what you are and are not permitted to do, and what opportunities you do and do not have? It's not about what opportunities did you actually take up, or did other people actually take up from time to time.
Did you say that the government were completely wide of the mark when they argued that the fact that the wife and son lived with him, the inviolability of his home, the intimacy of his family life, they said these were pointers to the fact that these were inconsistent, these were two rights guaranteed solely to free people. I mean, that was their argument.
Yes, well, I'm sure if any of us had been arguing the case for the government, we would have wanted to make the point. Yeah. But the important thing is that the court didn't seem to regard that as a factor in deciding whether or not there was a deprivation of liberty. They looked at the opportunity. What there was the opportunity for the family to be there. And it was an opportunity which was, in fact, taken up at most, but not all, of the time that Mr. Kutsadi spent on Asinara. While we are in this bundle, can I also ask to look at the other cases starting first of all with Engel, which is at tab 22. And can I please start at page 653, paragraph 16? At paragraph 16, the court sets out 4 categories of punishment which it was concerned with. So light arrest, strict arrest in the next page, although that's actually that's skipping over one level of severity, because the next level up from light arrest was actually aggravated arrest. So light arrest, aggravated arrest, strict arrest, and then committal to a disciplinary unit. Going over the page to 654, the court set out in a bit more detail what this would entail for different types of servicemen. Just below the quotation on 654, in dealing with light arrest, the court noted the effect of the provision was that any serviceman under light arrest, irrespective of rank, had usually to remain in his dwelling during off-duty hours if he lived outside the barracks, otherwise he was confined to barracks. Officers and non-commissioned officers normally lived outside, whereas ordinary servicemen were, as a rule, obliged to live within the barracks. In practice, ordinary servicemen had for some time enjoyed a degree of freedom of movement in the evenings between 5 o'clock and midnight and at weekends. They often made use of this to stay with their families, but this did not mean that they were no longer required to live in barracks. By reason of the above, an ordinary serviceman, unlike an officer or NCO, was in general not able to serve light arrest at home, and he thereby lost the privilege of returning to his family home during off-duty hours. And then there's some points of historical detail in the rest of that paragraph. At 19, aggravated arrest, which applied only to NCOs and ordinary servicemen, those concerned continued to perform their duties, but for the rest of the time had to remain in the company of other servicemen undergoing a similar punishment in a specially designated but unlocked place. Offender might receive visits if he had the company commander's written permission. Unlike a person under light arrest, he could not move freely about the barracks so as to visit the cinema, canteen or recreation facilities. As far as possible, ordinary servicemen had to be separated from their fellows during the night. Strict arrest, covering both duty and off-duty hours, was served by officers in a similar manner to light arrest, that is, they usually remained at home, whereas NCOs and ordinary servicemen were locked in a cell. All ranks were excluded from the performance of their normal duties. And then committal to a disciplinary unit, the most severe form of penalty, it applied only to privates. This punishment consisted of submitting the offender to a stricter discipline than normal by sending him to an establishment which was specially designated for that purpose. Service in a disciplinary unit was imposed for a period determined when the penalty was pronounced of from 3 to 6 months. In this respect alone did it differ from committal to a punishment unit, supplementary punishment which could be imposed on a serviceman in the context of criminal proceedings for a period of from 3 months to 2 years. Committal to a disciplinary unit, when it was ordered towards the end of military service, generally delayed the individual's return to civil life. Its execution was governed by a decree which concerned both committal to a punishment unit and, in principle, committal to a disciplinary unit. Those undergoing such punishment were removed from their own unit, placed in a special, separate group. Their movements were restricted, carried out their military service under constant supervision, and emphasis was placed in their education. And then the remainder of that paragraph deals with the 3 sections of those disciplinary units which became progressively less strict. So that's a description of the punishments that were involved. The facts of the individual cases start at page 659. Mr. Engel was the first relevant individual. I say relevant because only a small number of these individuals' cases were considered fully. Mr. Engel was serving as a sergeant in the Netherlands Army. He in fact lived at home during off-duty hours. and then it sets out the reasons why he was punished. So all that says there is that he was at home. And then the other two individuals are Mr. Donner and Mr. Schul, who are at the bottom of page 662. Mr. Donner, serving as a private, was editor of a journal called Alarm, published in censored form by the Association of Servicemen, and collaborated in particular in the preparation of a particular issue of the journal. And then the facts of the complaint against him are there set out in the rest of that page, the top of the next page. And then at paragraph 45, Mr. Schul, a private in the army, was also an editor of the journal Alarm. Facts regarding his cases are identical to those of Mr. Donner's, except that his punishment initially amounted to 4 months committal to a disciplinary unit, owing to the additional aggravating circumstance of his participation in the publication of an information bulletin for new recruits, the distribution of which had been prohibited by reason of its negative content. So that's all that's said about the individual's personal circumstances, which is relevant. So can I then go on to the court's actual decision about this, because that's where one sees the factors taken into account. At page 669, paragraph 58, the court sets out what are now familiar terms of the principles. And then at the bottom of page 669, the passage relating to servicemen, which has been quoted in our domestic case law. And then at paragraph 60, the court begins to look at the different types of punishment concerned. So at 61, the court says no deprivation of liberty resulted from the 3 and 4 days light arrest awarded against Mr. Engel and Mr. Van der Wiel, although confined during off-duty hours to their dwellings or to military buildings or premises, as the case may be, servicemen subject to such penalty are not locked up and continue to perform their duties. They remain more or less within the ordinary framework of their army life. So again, we make the point here that there's no reference to the personal circumstances of the individuals and their choices as to whether to live on barracks or to remain at home. And indeed, even where the individuals were living at home, no discussion of whether they had family or what sort of family they were living with, and so on. Aggravated arrest, similar point to be made, nothing discussed there about such person-specific matters. Strict arrest, the factors there that lead to that being regarded as a deprivation of liberty. Non-commissioned officers in ordinary service and served it by day and by night, locked in a cell, and were excluded from the performance of their normal duties, thus involved deprivation of liberty. And then committal to a disciplinary unit, one sees, unsurprisingly, that that's regarded as a deprivation of liberty. And so, looking at all of that as a whole, one simply doesn't see any trace of person-specific matters being discussed by the court as relevant to the question of whether or not there's been a deprivation of liberty.
Had they argued that it was? They argued on the basis of family matters? I couldn't quite see them. do something about doing an exam or something.
Peripheral matters surely only come into the picture in a situation where you're not locked up all the time. And then the issue arises as to whether what's happening when you're not locked up is of any relevance. And the Strasbourg Court has said it is relevant. But if we're dealing with situations where people are locked up, it's not surprising that one's not focusing on personal circumstances.
Indeed, but there is, in the case of light arrest in particular, that the element of choice that the individual serviceman had, whether to live on barracks or at home, in practice, those who are not officers did often live at home, and Mr. Engel was one of them. And if the question of person-specific factors was relevant to the question of whether he had been deprived of his liberty, one might expect to see some mention made of that.
But had Mr. Engel argued that?
But he had certainly made a point of the fact that he was living at home, and he had made a point of the fact that both the technical and the actual position relating to ordinary servicemen. So the fact that he was living at home is at paragraph 33.
Yes, I see that.
And then if you go back to page 634, it's within paragraph 18. You see, any serviceman under light arrest, irrespective of rank, either had to live at home or live in his dwelling outside the barracks, if that is where he normally lived, otherwise he was confined to barracks. So that's number one. The number two rule is that ordinary servicemen were obliged to live within barracks. That was the rule. In fact, they often didn't stay in the barracks overnight, but like Mr. Engel appears to have lived at home. And if he was serving light arrest, he would lose the privilege of returning to his home during off-duty hours. So there is an interference there.
I'm sorry, Mr. Tanano, I thought the court held that light arrest and aggravated arrest, the two lower forms of the four, did not involve the deprivation of liberty.
That is certainly what the court held.
Quite. So the only ones that did were the other two.
Indeed.
But what the court also said was, well, that's true for servicemen, because they've got to expect a bit more. It might be different for non-servicemen if you subjected them to regimes like light arrest or aggravated arrest.
Yes.
And they say at the bottom of paragraph 59, they said, last 6-7 lines of page 669, a disciplinary penalty or measure which on analysis would unquestionably be deemed a deprivation where it's applied to a civilian may not possess this when imposed on a serviceman. Nevertheless, it doesn't escape Article 5 when it takes the form of measure, etc., etc. And then over the page, I think that's the beginning of this then endlessly repeated phrase about how the court takes account of the whole range of factors, such as the nature, duration, effects, and manner of execution of the penalty. That's, I think, the origin, am I right, of that particular phrase?
Lord, yes. But the point is that even under light arrest, I know what the court found, having looked at it all, but it's the way in which it reached that conclusion which does not appear to give any weight to the possible choices.
3 days or something. I mean, it was short periods for Mr. Engel, for example. 3 days, 4 days, or something. I mean, is that going to be a big factor?
Well, Lord, I may be trying to place more weight on this than it will bear, but it is all of a piece with what was then said in Guzzardi, and one sees the absence of any mention of this factor in Guzzardi when it was a point which the court could very well have said something about.
I mean, speaking for myself, I'd find it awfully helpful if you showed us any case or any Strasbourg passage which dealt with the converse. I mean, they say you take account of the whole range of factors, such as, I've just read it out, nature, duration, effects, manner of execution of the penalty. Is there anywhere where it says, but actually you must ignore things that you say we've got to ignore?
What Strasbourg does say, and what does come across clearly, is that this is an objective approach. And that is what we point to support this argument. That and the consequences for...
Well, we haven't seen that so far, have we, in these two cases? Have we seen an express reference to an objective approach in Guzardi or Engel?
Well, this is what one gets from these, and the objective approach is then firmly set out in the JJ case.
I mean, it depends what you mean by objective, but it all depends what's meant by the whole range of factors, such as the nature, duration, effects, and so on.
Yes.
Because its common ground is that effects means effects on the particular person.
But as I said before the short adjournment, we respectfully point to Lord Bingham's words in paragraph 15 in JJ. It's not the impact on the person concerned. It's the impact on a person in the situation of the person who is subject to these measures. And we say that this is clearly looking at the effect of the package when viewed objectively. And the notion of the objective viewpoint is one that runs right the way through.
What I'm saying is that we haven't seen anything in these two cases we looked at so far beyond the expression, duration, effects, and so on, have we?
No, but one can't... that is the whole approach that these cases adopt. Finally, in this bundle, can I go to tab 21, which is Ciancimino? Can I please start at page 117? So the paragraphs in this print are not numbered. The history of the compulsory residence order set out on page 117 onwards. At 118 in the penultimate paragraph, you see the decision of the Palermo District Court deciding to impose the measure of compulsory residence in Rotello for a period of 4 years, plus an 11-hour curfew overnight. And then when implemented at the top of the next page at 119, he was not to leave Rotello without permission to report once a day, and then the curfew there imposed. And then in the decision, which starts at page 120, halfway down the page, the Commission setting out there the tests which we seen in the other cases. And then the factors which were prayed in aid by the government, you see at 121 in the third paragraph, emphasising the location of the commune, essential public services and places of worship, communications with the rest of Italian territory, and he was living there with his close family. And then going over to 122, halfway down the page, Commission reciting the test, and then here are the factors that the Commission takes into account. In this connection, the Commission notes, first of all, the compulsory residence order was enforced in a commune where the applicant's living conditions were the same as the rest of the population. It appears that the decision of 5th July 1985, together with the police report of 26 November 1985, the applicant could move freely inside the limits of the commune during the day. With regard to supervision, the applicant's not proved that it exceeded the limits of what was reasonable, bearing in mind the nature of the purpose of the measure, which was to subject the applicant to special police supervision. Consequently, the Commission considers that the length of period during which the preventive measure was applied, which in this case was 2 years and nearly 10 months since the order requiring the applicant's compulsory residence was changed, does not in itself make that measure a deprivation of liberty. The Commission considers that in this case a special supervision measure applied to the applicant did not constitute a deprivation of liberty within the meaning of Article 5 of the Convention. So, the Commission obviously touching quite lightly on this, but again, family factors having been mentioned, it's notable that they are absent from the factors which the Commission itself is specifically looking at when it's deciding whether or not there has been a deprivation.
This dog that didn't bark might support a proposition that being deprived of the company of one's family is not a relevant factor when considering whether you've been deprived of liberty. But that's not the point you're making. As I understand it, you accept that if the move had in fact caused AEP to be deprived of the company of his family, that would be a relevant factor. But you say that wasn't really the cause. It was the cause that his family didn't choose to go to visit him. So really you're taking a point of causation. But we haven't seen anything that bears on that point here at all.
In a sense that there is an element of trying to prove the negative from these in showing you that the court and the Commission have not referred to the factor, even where it was a factor there that could have been referred to. And it's always difficult to prove a negative and always difficult to make a legal argument.
But I haven't seen anywhere any suggestion that deprivation of company of family was attributable to the choice of the family, which is the point you're making here. You're saying family could have gone to visit, but they didn't choose to do so. That should take that out of the picture.
But what we, with respect, draw attention to is the fact that where one could have expected to see some mention of that, there isn't. Of the choices of the family as to whether or not to be there or not, if it was possible for them to be there, and it's not mentioned. The entire approach.
The family were with them, were they not?
Yes, in the case of Chanchmina, but looking at all of these cases, the entire approach is one of looking at the objective, looking objectively at the measures. What are the measures? What obligations do they impose? What freedom do you have and what freedom do you not have? Not whether you take advantage of the freedoms that have been offered to you within that package, and that is the point I'm making from these cases. If the court and the Commission's approach was not just to look at what opportunities does the package afford you and what opportunities are you denied, but also at whether or not you or your family are actually taking advantage of these opportunities. If the court and the Commission were taking that approach, which is the approach which my learned friend asked this court to take, one would expect to see some reflection of that there, but the entire viewpoint, we respectfully say, is different, and that's a point we do draw from this. Lord, although this is a different argument, as we still have this bundle open, can I perhaps go straight to what would have been the last case in the series, which is the case of Shtukaturov and Russia, which is more recent decision. It's at the end of the bundle at tab 29.
Sorry, tab what?
29. It's the last tab in this bundle. It's a mental health case. So the context we accept as different. But we do draw attention to one passage in the court's decision on page 21, starting at paragraph 104. There was in this case an issue as to whether or not the applicant's hospitalisation was voluntary. It was categorised in domestic law as voluntary, but the court didn't like that.
Was this somebody admitted by his mother?
His mother, that's right. Admitted by
The
his
voluntariness was said to be on her part, because she was guardian, is that it?
That's right. And so, as a matter of domestic law, it was regarded as voluntary. So the court, the Strasbourg court didn't.
She wanted him in, but he didn't think he ought to be there and didn't want to be in.
Yes, and he thought he shouldn't be there, and he asked it to be let out. But can I draw attention to this passage? The government may be understood as claiming that the applicant's hospitalisation was in domestic terms voluntary, and as such did not fall under the scenario of deprivation of liberty within the meaning of Article 5 of the Convention. However, the court cannot subscribe to this thesis. It reiterates, and then it sets out the Guzzardi test with which we're familiar. And then it says the court further recalls that the notion of deprivation of liberty does not only comprise the objective element of a person's confinement in a particular restricted space for a not negligible length of time. A person can only be considered to have been deprived of his liberty if, as an additional subjective element, he has not validly consented to the confinement in question. Now, the last part of it is I accept, to do with whether the individual says, "Okay, I'm happy to be in the hospital, or I'm happy to be locked up in wherever." But the contrast that is drawn there is between that and looking at the objective element, which appears to be a reference back to the concrete situation, the whole range of factors such as type, duration, effect, and manner of implementation.
But that simply means objective in the sense of including effects. One of the relevant effects is lack of social contact. And the lack of social contact here was the lack of social contact with his mother, because his mother did not go and see him as a result of the order. And there you have it.
Well, we respectfully say that it is telling that the court uses the adjective objective, because it is all of a piece with the submission that I've just been making. When one looks at, in the other cases, in Guzzardi and Engel and so on, and so far as one can see it, when the court is looking at factors which bear on the question whether there has been a deprivation of liberty, they are all objective factors.
But as I put it to you just a moment ago, it is an objective question. You simply ask, was, as one of the factors, it's relevant to consider what social contact the controllee had. In this case, there was a lack of social contact because his mother didn't go and see him, and that lack of social contact was caused by, or an effective cause of it, was the control order. And all that can be analysed in a purely objective way. And there you have it.
Well, we respectfully say that it is...
I mean, what's wrong with that analysis?
We respectfully say it's inapt to describe that as objective, and it's inapt because it would lead to the consequence that we've already described, that somebody may be deprived of their liberty or not, simply because a family member says, well, I can't be bothered to go
Mr.
that
Tam,
way.
does your point come to anything more than one of causation?
Yeah.
Was it this feature of the control order, as a matter of ordinary causation, that resulted in AP being deprived of the company of his family, or was it not? And wouldn't one answer that by saying, was this a reasonable and foreseeable consequence, that the impediments to contact with his family that resulted naturally from putting this man 150 miles away from them was likely to mean that he didn't enjoy their company? Just as likely to mean he didn't enjoy the company of all these would-be Confederates in terrorism that the separation was designed to achieve.
We wouldn't wish to categorise it merely as a question of causation, because if it were simply a question of causation, it takes away the fact that the control order obligations afford the individual quite a wide, or the individual and his family, a wide space in which to make choices about what they are going to do. And it could be said that anywhere within that, their choices are caused by the fact that the control order has been imposed on them, which would simply, in a circular way, bring us right back to the problem that I've already described, which is that the question of whether there's a deprivation of liberty just depends on whether or not the family member, or might depend on whether or not family members can be bothered to go as far as they need to go, and one family might be and another family might not be. So,
But why is the test of causation not quite sufficient? Of course, there may be a break in the chain of causation, as in Mr. Justice Mitting's case, where the family didn't go and see him because they refused to tell the Home Office or whatever it was. And the judge thought that broke the chain of causation. And so obviously you could have a break in the chain of causation, and there are all kinds of other examples which one can think of. But as long as one can say, the judge can hold on the facts that a cause of his being deprived of the particular social contact was the control order, then why is that not sufficient to satisfy the question, or to answer the question, whether the lack of social contact was an effect, to use the expression used in the cases, of the order?
My concern would be this, that what it would enable a controlled person to do would be to blame all sorts of things on the control order, which were in fact matters of choice that were perfectly possible for them to make. Sorry, that's probably not very elegantly phrased. There are also we accept that if a control order is imposed, it's obviously going to require adjustments to be made. So immediately AP was put onto site, bail, for example, and released to the North London address. That requires the family to make adjustments so that they actually have to travel to North London to go and see him and visit him. He's not going to be at home, and he's not free to be at home. So that's an adjustment which some people might make and other people might not make. And if it were purely a matter of causation, the controlled person and his family might simply say, well, we can't actually even get over to North London because the children need to do this and we haven't got childcare facilities for that. And it's all just very difficult and we're not going to do it. And one might have been faced, if you're going to look at the pure factual question of whether the family are actually visiting him, faced with a position which is actually no different in North London from how it would be in the town where AP was in fact relocated to. And there's a second difficulty with looking at it just as a matter of causation, which is that you could not work out whether or not the control order had caused a particular problem.
But judges are resolving causation questions up and down the land, in every conceivable kind of context, yes, all the time.
I accept that causation issues are resolved by courts, but there is another difficulty in this context, which is this, that the question of whether the control order has caused a particular effect, such as the family not going to see the individual, couldn't be predicted in advance by the Secretary of State. It's another aspect of relying on matters of individual choice to govern whether or not the individual has been deprived of his liberty. And we respectfully say that it would be odd if the Secretary of State, as a matter of principle, had to say, well, I think that this is okay because I think that a reasonable family would actually make the journey up to wherever it is, however far it is. And then later it turns out that the family have got some good or bad reason for saying, no, actually, we're not even going to go that far. And the Secretary of State has to take the risk that is the case and take the risk that he actually never had the power to make that particular order or impose that particular modification.
So what is your position then? What should we do on that? What's the correct legal analysis?
The correct legal analysis, we respectfully say, is that you should look only at those matters which are properly classed as objective, those things which would affect any person who is subject to that particular...
So you ignore the family?
You disregard effects that are produced by the family's choices about whether or not they're going to take up the opportunities and freedoms that are available to them. And that is what this is about at the end of the day.
Does the Secretary of State have to, faced with a controlee who is married and got children and so on, and one who's not, and let's say his parents are dead and so on. So does the Secretary of State take those factors into account or not?
The Secretary of State would have to take into account that the family exists and that he has a family life, and if he's to be removed from his family, that he is being removed from the family. But the Secretary of State does not have to try and guess in advance whether the family are going to visit him, whether they're going to go once a week or twice a week, or whether they're simply going to refuse to go altogether. That is a sort of choice which we respectfully say is entirely for the family to make.
What does the Secretary say? He says, well, this guy has got 2 children or something like that. What does it, after having noted that,
yes,
what does the Secretary of State do?
Well, the Secretary of State,
in that respect?
Well, the Secretary of State will have noted that he's got children. If they're children of school age, there will be inevitable things that come with that. That arrangements will have to be made for childcare and so on if he is to be removed. The Secretary of State might decide that all of that actually makes it wrong to relocate the individual at all. But if he's deciding to relocate the individual, then those are things which are objectively established. Any father who is to be removed from his wife and children will end up suffering that separation, and the rest of the family will have to deal with the practical consequences of that. Those are inevitable. But what the Secretary of State, or what it's going too far, is to ask the Secretary of State then to predict in advance whether the family are in fact going to use their freedom to go and travel to visit him, and if they are, then how often and for how long, and whether they're going to stay with him when they go up there, or whether they're just going to visit for the day, and things like that. Because all of those things are matters of discretion and choice for the family. If they're perfectly possible for the family to do, then we respectfully say that they can't govern whether or not the package amounts to deprivation of liberty.
But if you introduce the concept of reasonableness into this, why can't the Secretary of State make a judgment as to whether a family in this situation under consideration, about to be separated from the controllee by 150 miles, whether the family would reasonably be able to make the visit? And if he came to the conclusion that the family would reasonably be able to make the visit, then he could make the control order. But if he came to the conclusion that the distance was such and that the cost of getting there was such, because he would know, I mean, we're told that the mother is on, I think, income support in this case, is a person of very, very limited means. Why shouldn't the Secretary of State be required to have regard to matters of that kind in reaching a conclusion as to what the reasonable consequence of making the order would be on the family?
That analysis, and I'm hesitant to traipse back into the difficult territory about Article 8 and Article 5, but we respectfully say that that is actually where that sort of analysis ought to be made, because that is classic Article 8 territory. Certainly, for the purposes of Article 8, the Secretary of State would have to look at all of that and would have to ask himself the question, what is the extent of the interference, and is it justified, is it really necessary in order to achieve the aim that the Secretary of State wishes to achieve. That was, as you've seen from the judgments in this case, that was all looked at in the context of Article 8 as well. But the very different area of Article 5, where you're trying to work out whether somebody's been deprived of their liberty or whether the restrictions are just a restriction on his freedom of movement, we respectfully say it's wrong in principle to be putting into that analysis factors which ultimately come down to a matter of individual choice and person-specific impact.
Well, supposing for Article 8 purposes, the Secretary of State, as you say, considers all these matters and says, well, looks as though they're only going to be able, in practice, to visit once in 6 weeks or something like that. But having regard to the importance of the objective, which I have here, that's all right. I'm satisfied that it's proportionate. Now, does he then, when he goes on to Article 5, he carries with him the fact that he's decided that probably he's only going to be able to visit once in 6 weeks. Now, what does he do with that, if anything, in Article 5?
As far as Article 5 is concerned, we say that he shouldn't be looking at the matters where, or the matters about which the individuals are choosing whether or not to go. Are they choosing to go once every 6 weeks because they are not making the adjustments which they could make with more effort to go more often?
Well, you're not to consider that under Article 8.
Under Article 8, the Secretary of State is not having to take a hard-edged view about whether or not he's got the power to make a particular order, because that is the hard edge of the Article 5 field. We respect to say that it can't be right that it's a deprivation of, supposing the Secretary of State were to take the view that in a particular set of circumstances that this particular family will only go once every 6 weeks.
Will only really in practice be able to, reasonably you can't expect them to go more than once in 6 weeks. Let's just say that's his conclusion, having looked at the circumstances. Now, what does he do with that, if anything, when it comes to Article 5?
Well, we respect to say, as far as Article 5 is concerned, he should be taking a step back from things which are person-specific, because if there's a particular package of obligations, it really ought to come to the same result, irrespective of the person-specific factors or the family-specific factors in the case.
So he has to look at family-specific and all that, and the likelihood and what's reasonable, what may be expected for Article 8 purposes, but shut his mind to those considerations for Article 5.
Because, well, that's an inevitable consequence of the fact that these are articles which cover different fields. They're trying to do different things. And really under Article 5, the question is, perhaps one can put the question like this: how close is it to being locked up in a prison, or how close is it to being in an open prison? And the answer to that ought to be the same, whoever it is who's being put into the open prison, and whether or not the...
But you've already conceded that that's not the case, because if you've got no family, the position is different than if you have got a family, so that won't do. I mean, the fact is that under Article 5, we're simply construing what it is Strasbourg meant, to my mind, because it isn't a question of discretion, it isn't the poor old Secretary of State point at all. The question is whether or not this person has been deprived of his liberty within the meaning of Article 5 as defined in the authorities. And we know from Guzardi that it isn't a simple question of looking at the confinement and asking yourself, has he been deprived of his liberty? It's a more complicated question of that. It might, if one took Lord Hoffman's approach, it would be different. But the fact is we have Guzardi, and we know that what you have to do under Guzardi is identify what the effects are of the order. And we know that's quite a complicated question. We know, as they said in paragraph 93, that it's a matter of judgment. you have to assess all these factors. Well, I'm afraid the Secretary of State simply has to assess it, just as when it comes to the judge has to assess it. It's a matter of assessment, in the first place by the Secretary of State and then by the judge. And there we have it.
Well, Lord, I suspect I've travelled over this backwards and forwards now. I suspect I've really said all I can say on this point. So,
Could you just help me by giving me your definition of what you mean by person-specific?
Certainly in the context of this case, we can see them very clearly. They are the matters which are ultimately a matter of choice for the individuals concerned. The choice of the mother not to travel on her own outside London, the choice of the family, or the consequent choice that they could only go up, if at all, on Sundays during term time, although perhaps more often during school holidays. There are choices about the times at which they could travel, which has an impact on the cost and therefore the financial feasibility. Those are things which are all person-specific, because they do depend very much on the individual circumstances of the family. And when we say that wherever you might, in theory, put the dividing line between the objective things that the Strasbourg court is looking at in all those cases and these person-specific factors, these are clearly person-specific. They are clearly factors which are a matter of choice. And if nowhere else one can see that from the apparent inconsistency between paragraphs 88 and 97 of Mr. Justice Keith's judgment, that can only be reconciled by recognising that the fact that the family did not visit was their choice not to visit, for reasons which one can understand, but it was still their choice.
And if mother's health is such as to prevent her travelling as far as that, is that person-specific and to be ignored?
That is, because that would be a matter of her own personal frailties.
It wouldn't be a matter of choice, though.
Not a matter of choice.
So choice can't be the test.
It's
So
not
now
just...
widen the test. We had idiosyncratic choice. Now we've got something else.
You said frailties earlier on.
We have said frailties, and in our printed case we have made very clear that their choices and frailties, they are things which are specific or idiosyncratic, rather than things which are objective.
Because some might say that that is to identify the family too much with the individual. I mean, the fact is, if Strasbourg is looking at what effect all this has on the individual to decide whether or not the line is crossed, one might say, well, it's the fact that nobody comes to visit him, which is the critical point. Why they don't come is neither here nor there. And to treat the mother and the son as if they were all part of one decision-making entity may be wrong in principle. I don't know. I'm not saying that is the position, but your argument does treat the family and the controllee as one sort of decision-making group.
Well, again, on the facts of this case, there's no conflict between them on that. It may be that in other cases that if there were some conflict between what they wanted, the analysis would have to be amended accordingly. But here, as in many, if not most of these cases, that they are at idem on this, that there's no conflict between them, and they say the same thing about
Poverty, is that person-specific?
That would be person-specific.
That would not.
Would be.
Would be.
Would be person-specific. That's a characteristic of the individual.
That's not a matter of... That's not a matter of choice.
But it's part of...
See, I'd written down, when I asked you the question, what you meant by person-specific, and I wrote down those things that are matters of choice of the person concerned.
Or frailties, as we put it in our printed case.
Could you put it again so I can understand what you're submitting person-specific means?
Matters of personal choice or individual frailty. And I think that by analogy, if there were poverty that that stood in the way that would fall into that category.
But one assumes people who are well, who make reasonable choices, and who are not poor. That's the model which we have, the Secretary of State has in mind. Is that right? Anything that falls outside that. Is that right?
That is right, but I know that sounds stark because one can see the consequences of that. And what I would be at pains to stress is that, of course, Article 5 is not the whole issue, because it may well be that a particular package, when assessed in this way, does not deprive the individual of his liberty, but requires amendment for other reasons. Article 5 is not the sole thing in play in these cases, as you can see from the judgments themselves. It might be quite unreasonable and therefore unlawful for other reasons, why, if the family are destitute and can't travel, that this may not be an appropriate modification to make. The very narrow focus of this case is on whether it is technically a deprivation of liberty or not. And that is why some of the answers I give may appear to be quite stark. But it's not that once we've done that, we just ignore all the rest of it. The rest of it has to be taken into account, but taken into account elsewhere. And in the field of families, of course, primarily Article 8. That is why there has been this interplay between Article 8 and Article 5 throughout. So I wouldn't want it to be thought that we would just say, well, that's tough luck. But it's not an Article 5 problem, and that is fundamentally our case.
Can I come back to your person-specific definition as you've now given it to us? That would mean you wouldn't take into account the fact that the controlee used to live with his mother with a very good relationship, is then moved elsewhere in the country. His mother is disabled, and it is quite impossible for her to visit him. Would that be a case of individual frailty, and so to be ignored?
Well, to tease out the various strands of that, some of those are, of course, objective. So, for example, if the individual is being moved away from home and moved to a new place, that is something which will have effects on everybody in his position. The fact that his mother has an individual frailty is something which we would respectfully say is not to be taken into account under Article 5, but as I stress, under Article 5 alone. That it may be something which the Secretary of State can't lawfully do for other reasons, but not Article 5.
The other reasons being 8 or just general.
Well, in an extreme case, one might just say straightforward old irrationality. Yes, even the ECHR is not the only answer to all of these things.
Of course.
That is our argument on the main ground of appeal. The other two arguments, or the argument we have on the other two issues in the case, we've set out in our printed case, particularly in relation to the third one, the inconsistent findings. I think I've been through how it might be inconsistent or not inconsistent, depending on how you read it, and I don't think I can really usefully add anything to that. On the main issue, those are our submissions, unless I can assist any further.
Have we got in the Honourable Authorities the case that Lord Justice Carnwath refers to at the end, RB Algeria? I couldn't see it, but it may be.
No, we don't have RB Algeria.
I mean, it's usual that you do give us almost too much, including certainly everything that's referred to in the judgments. But I thought here that anyhow we can find it.
Yes, my Lord, if it would help, we can certainly.
No, we get it. It's in all the report.
Thank you very much. Mr. Ike, do you wish to add anything? Mr. Fitzgerald, you haven't supplied us with a speaking note in We anticipate from that your reply may be fairly brief.
Just the first point is that
Could you switch your mic on? I'm not sure it actually has any impact, but at
Oh, yes. Yes.
an effort.
Yes. If my learned friend is right, then it's quite simple. You can effectively write an all-purpose control order now. You just simply say 16 hours, because that can be acceptable. 1 hour, 45 minutes away if they've got family, because it's clear that that's feasible. If the person's religious, you just check that there's a mosque there, whether or not the person will be acceptable to the particular mosque. And as to isolation in an alien environment, which was the feature that the judge attached significance to, that apparently is not enough to make a difference in any event. And what he then excludes as person-specific is, firstly, all choices that are made. It's only if it's, as it were, impossible to make the journey. So however difficult it is, you just exclude those as all choices. And now my learned friend says, consistently with his case, all frailties, so physical disabilities, poverty, all those matters are excluded. And really, one's very, very far, in our respectful submission, there from the Guzzardi test and the JJ test. If you look at a whole combination of facts, nature, purpose, and the effects, because you're not looking at the effects. You're saying we're going to look at a kind of sanitized version of the effects in some notional theoretical case. And that's so contrary to the whole language of look at the concrete situation of the actual person, look at the specific person, that it simply can't be right. I mean, my learned friend is virtually saying there is a one all-purpose control order that would fit it. Of course, it is true that given the judgments of the hospitals as it then was, in JJ and AF and E, it is pretty foreseeable that if it's only 12 hours, then that will be determinative that it is an acceptable control order. So it's not as if the Secretary of State's got no guidance at all. It's pretty foreseeable that if it's only 12 hours, it will almost inevitably be okay. And that if it's 14 hours, it would have to be very, very extreme circumstances. So it's not true that him saying that how can I possibly know what will pass muster as not constituting deprivation of liberty. But once you're on 16 hours, it's quite clear that you are, as it were, playing with fire when it comes to deprivation of liberty, and it doesn't take much to tip it over into constituting deprivation of liberty. And we respectfully submit that that's entirely in accordance with the principles of the Convention.
Mr. Fitzgerald, after Mr. Aske's order here, we know that the Secretary of State actually served a modified control order down to 14 hours, but leaving the Midlands requirement.
That's right, my Lord, yeah.
I mean, was that appealed?
It was appealed, but that appeal was never heard because it was overtaken by events.
I see it, but it was appealed.
It was appealed, my Lord.
I
yes.
see.
Yes.
I mean, as I understand it, since JJ, no challenge to a 14-hour curfew has ever succeeded, although Mr. Justice Mitting, said it came to the borderline, something like that.
That's right, my Lord. So clearly, if the Secretary of State is saying, look, I don't know what on earth I can do and what I can't do, the answer is pretty clearly 12 hours. It would be difficult in the light of the authorities to envisage that falling foul. 14 hours has never, as your Lordship said, been classified as deprivation of liberty, but there is the question of 14 hours were very extreme. 16 hours, you know, if you're the Secretary of State, that you are in very dangerous territory. And therefore, there's nothing wrong or surprising about saying, and you'd better have done your homework on the effects, or the likely effects.
Have any of these cases yet gone to Strasbourg? No.
No.
Are they going?
I'm terribly sorry, I don't know. I don't know the answer. Not that I'm involved in. But I don't know.
It is very odd in a way, isn't it? Maybe this comes from the way Strasbourg's approached it. But it is very odd to say, well, 16 hours, we're arguing about 16 hours here, and it's said that because of the lack of social contact with the controlee's mother, that tips the balance in favour of a conclusion that it was a deprivation of liberty. But if you move the 16 down to 14, or maybe even 15, then you're okay, or the Secretary of State's all right, even though there's the same lack of contact with the mother. It's very odd. I mean, somehow one doesn't seem to be comparing like with like, or apples with apples and oranges with oranges. It's a very, very peculiar principle. But there it is. Maybe we'll stop.
I do accept that, but that's because the core element, if it's not enough, you're not in the territory at all. But once you are certainly in the 14 to 16 area, then it doesn't take much for.
I understand that, but it still seems very odd.
My lord, I accept it's not.
Thinking of social isolation, are there any cases in which control orders have been made particularly against two brothers who occupy the same premises, or is it always solitary confinement during the curfew?
Sometimes they're in their own family, of course. They're staying in the flat where they lived with their family. E, for example, was with his family, and AF was with his family.
So there are some control orders against a single individual where they are not in solitary confinement during the curfew.
That's absolutely right. And that was a significant factor in E and in AF.
Yes, thank you.
And obviously in some of the cases that your lordships have, the three first instance cases.
Sometimes they are sole people. I mean, they are without any family.
Absolutely. Of course, again, my lord, I know this is just a general point, but there aren't very many of them, and therefore one isn't dealing with even scores. And I think we're dealing with about 12 people in all, and with obviously a controversial and highly intrusive order in the first place. So the fact that it requires this elaborate scrutiny is not surprising, given that it is far more exacting as a regime than what the Italian government found to be sufficient to break up, after all, one of the most organised crime organisations there is. That's sufficient to deal with that, and in terms of the mafia cases. So, my lord, can I turn again from that background just to the question of how this issue should be addressed? In fact, in our respectful submission, most of my learned friends' points, being about choice, can be catered for by a causational test, as my Lord Clark and my Lord Phillips put to my learned friend, and indeed we saw it in the last of the items on the subjective-objective test. It's a question of what are the natural and foreseeable consequences of the measure, but not of the situation brought about by wholly unreasonable or eccentric reactions. And that explains the AU case. Then
I'm not sure if that's what some people might call a perfect antithesis. I mean,
yes.
Don't you want natural? I mean, wouldn't you be better with reasonable?
Yes. I see. Yes,
reasonable and foreseeable.
Yes.
I mean.
Yes, reasonable. I'm so sorry. Yes,
well,
yes. Well, naturals can sometimes mean yes, but I accept yes. The reasonable and foreseeable. With a reasonably foreseeable consequence.
Yes. I mean, even because you really want to say, well, I mean, even if it would have been also reasonable to have gone up more. The fact that they haven't
Yes.
isn't to be counted against you.
That is correct, my lord.
I mean, really, what you're saying is it's okay to say the family can't be allowed to thwart a control order and its conditions by unreasonably not taking up the opportunities, but otherwise you should have regard to them.
Yes, that is our yes. In other words, if when one looks at the measure, it's 150 miles away, and one looks at the situation, this is a impoverished family, and that then one says, well, it's perfectly foreseeable that it will make it very difficult to visit frequently as before. It's foreseeable that it may even reduce the visits to none or to very few. And you can't then say that that's not a consequence of making it very hard, that in fact the person is visited very infrequently or not at all. My Lord Savile put to my learned friend, well, do you accept that a consequence was that it made it very difficult and that that's relevant? And my learned friend said, yes, I do accept that it's relevant, that it makes it very difficult. But in that case, one can say, well, it clearly made it very difficult, and in fact, there haven't been any visits yet. And that's exactly the way that the European Court looks at these things. They first of all say, what is the tendency of the thing? And then they say, and what in fact has happened? And combine those two, and one can say that the regime has had these effects. And then, as my Lord Clark put to my learned friend, you can cater within the causational analysis for the break in the chain of causation, the ultronious, the eccentric, or the perverse refusal to comply with it. That is what was done in the AU case. So in our respectful submission, that is a way in which some element of extreme uncooperativeness can be catered for, but the basic point can be made, well, is this the reasonably foreseeable consequence of the order? I've made the point, the point on which my learned friend has advanced is not the point on which the Court of Appeal decided this case, and that's in Roman 4 in the summary. My learned friend hasn't sought to defend the principle that Article 8 compliant interferences can never make the difference. And my Lord Roger put to me, well, it doesn't matter that it's a new point, but there may be a bit of a problem if it's not a point that was actually thrashed out before Mr. Justice Keefe in the first place. And I think my learned friend accepted that it wasn't put in that way at the trial. So really what we have is that the basis on which the Court of Appeal decided this matter was an improper interference with the reasoning of the trial judge and on a wrongful basis. And my learned friend is now trying to justify it by reference to a principle which is really not very clear. I mean, if it's exclude choices, it can be catered for causationally. If it's exclude frailties, such as disability and poverty, it's frankly totally unjustifiable, because you've got to take the situation of the person and his family as you find it. Well, as to the paragraph 97 argument, my learned friend didn't persist in it particularly strongly, but we do submit it's unduly analytical to say it all hinges on a particular reading of that word could, and the apparent inconsistency of that with paragraph 88. We say, if you look at it as a whole, it makes perfect sense that he's saying it becomes much more difficult and you don't get the type of visits that you had before. My learned friend relied repeatedly on paragraph 15 of JJ. We respectfully submit that the words there about having regard to a person in that situation, it is, as my Lord Brown put it, it's saying you look at the type of situation he's in. If he's a civilian, it may be different than if he's military, and that's all it was meaning. It wasn't intending to say you don't look at the individual, but at some notional individual. It was actually just an example of the concrete situation principle, that you take into account whether he's a civilian or military, a person in the situation that he finds himself in. My Lord Dyson put the point, my Lord Sir John Dyson put the point that we're primarily looking at the controllee himself, and that, as it were, the family are one of the circumstances, as it were, if I can put it that way. I mean, and certainly one should look primarily at the controllee himself, and we would submit that would be consistent with adopting the causational approach, because then you look at him, the effect on him is his family haven't visited, and then you only say, well, we're not going to take that into account if the reason that the family haven't visited is in fact not the control order itself, but some perverse approach that they've taken. But otherwise, the way his family reacts to the order is simply a circumstance, an objective circumstance. And if, as a result of the order being made, they don't visit, that is one of the effects on him. My Lord, just yes, I think my learned friend made much of the fact that the family factors were not listed in Guzzardi, but it was accepted that it was a relevant factor, in fact a relevant factor for the government, that his family were with him all the time, and as my Lord Phillips pointed out to my learned friend, the paragraph 109, it was found that there was no breach of Article 8, because in fact there wasn't an interference with family life. So that's the reason that it doesn't feature largely in Guzzardi at all. My learned friend relied on Ciancimino, but really that doesn't say anything on this issue at all. Indeed, the contrast with Ciancimino is a point in favour of the appellant in this case, that Ciancimino was only 11 hours and no interference with his intercourse with the people in the township during the day at all. So, my Lord, on all those grounds, we submit my learned friend really has not justified the reasoning of the Court of Appeal, and insofar as he's come up with a new point, or a rescue point, in developing this point about subjective-objective, we submit firstly, the only thing that's subjective is the person's personal reaction, and it may be that if it's an extreme personal reaction, you ignore that. That's all that the subjective-objective test does, is that the fact that he regards it as deprivation of liberty, or that he's particularly upset by it.
What about his mental health? Mr. Starmer said you ignored that too.
Well, my Lord, we
don't have to decide.
We don't have to decide it, but we do put a bit of a question mark.
Yeah, I wonder about that.
It's one of the circumstances.
Yeah.
And you'll see that in our notes we've queried that. But the second point about choice is all catered for by causation. And it's clear that Mr. Justice Keith did think that the great restriction on visits was directly referable to the geographical distance imposed, and that therefore there was a causational link between the fact that he had no contact with his family and the fact that he was 150 miles away. And we say that was entirely reasonable that all the factors he took into account were perfectly reasonable. Your Lordships have our submissions as to frailties. We say it really would be pretty alarming if you just ignored the fact that people were poor, you ignored the fact that relatives were in wheelchairs, and you just said, well, you'll deal, that's got nothing to do with social isolation, because you've got to sort of invent some notional person who's healthy and moderately wealthy and et cetera, et cetera. And we really are in the realms of creating exactly the kind of problems one has in provocation of endowing an actual person with notional qualities of an average person, and that can't be the way to deal with this problem, which is you look at the concrete situation and only exclude the exceptional or wholly unreasonable choice which breaks the chain of causation. Those are our submissions.
Yeah, I just have one question, which is in relation to the nature of the exercise. The Prevention of Terrorism Act has its own procedure for appeal, but that's, as I understand it, governing an appeal against an order which is not challenged on the ground as ultra vires, but on one of the statutory grounds, namely that it's flawed.
Yes.
But this is a challenge to the varies of the condition. So are we simply in familiar territory of considering whether, as a matter of law, the order falls outside the power because it is actually an order which deprives the applicant of his liberty?
Yes.
Is that the analysis? So we're not concerned with questions of whether the order is flawed.
Yes. Because it's a non-derogating control order, there's no power to make it in this form. So it has to be struck down, and then the question is whether the new order that's issued, in this case, one has been issued of 14 hours plus would be itself.
But there was an issue in relation to the relief, wasn't there? Because the relief, I think, simply struck down one limb of the order, but didn't hold.
Yes, that was because it was a modification, and the provisions for appealing against modifications is section 10. Yes, appeals relating to non-derogating control orders, and it's section 10. In the case of an appeal against a renewal with modifications, the appeal may include appeal against some or all of the modifications. That's at 10.2. He can appeal against the renewal or modification. And so the grounds of the appeal... Yes, and then one of the powers, the one which was exercised here, was to quash the modification rather than the whole order. And I suppose he quashed the modification on the basis that you can't purport to make a non-derogating control order if in fact you're depriving of liberty. So that something had to be struck down.
I mean, the order is before... Sorry, I'm so sorry.
I think probably this is tilting to windmill, because in determining whether a decision is flawed, the court must apply the principles applicable on an application for judicial review. So if you're saying it's ultra vires, it's an ultra vires application. If you're saying that it's unnecessary or whatever, but not challenging the vires.
Yeah. Well, we're saying it's obviously
on the fundamental
ground.
ground.
We're saying it's ultra vires.
Yes.
But I hope nothing hinges on it.
And I don't think so. I just want
if
quite
it does,
clear.
Is the appeal to the Court of Appeal, is that under one of the provisions of this Act or the general jurisdiction? If it's one of the provisions of this Act, which provision is it?
Well, my learned junior says it's under the general jurisdiction, and that because there was a decision of the High Court. Is there a special provision? Yes. Yes, 11, I'm just looking, 11.1, but control order decisions are not questioned. Yes, I see. So 11.1b just is limiting what can be the subject of an appeal, but I think the authority for the appeal to the Court of Appeal is the general powers to appeal to the Court of Appeal, is that right? So sorry, my Lord.
I thought there was a provision which provided that the Court of Appeal jurisdiction was limited to issues of law. Was that wrong?
What is it?
That is certainly true in respect of deportation orders,
Yeah.
as in that RB Algeria case.
Yes.
I'm not sure. But I'm looking back at JJ, because this was an identical position.
Yes, section 11.1 seems to be the only bit that deals with. I see. Apparently, according to my other friend, it's section 11.3 that governs it, and
That's it.
and that's missing.
Yes.
What?
Ah.
What's he say?
We jump from page 16 to page 21.
Oh, I see.
So what does section 11.3 say? I mean, what does it provide, broadly speaking?
I'm just going to. I'm so sorry. It says, no appeal shall lie from any determination of the court in control order proceedings except on a question of law. So that's subject.
That's 11.1.3, is that right?
11.3.
11.3.
11.3, yes.
Of the 2005 Act.
Yes.
So that's the limit of the jurisdiction of the Court of Appeal in this
Yes.
class of case, and
Yes.
therefore presumably our jurisdiction, if you like, as well.
My Lord, yes. Yeah.
Thank you.
So, and that's why one sees both the judges in the majority stressing that it has to be a question of law.
Right.
My Lord, unless I can give any further assistance. Oh, yes, my Lord, at the moment there's no application obviously to lift the anonymity. So we would invite your Lordships to leave that order in place, as it were, until further order or further application. Obviously neither myself nor my learned friend are applying to lift anonymity, and therefore unless your Lordships feel that it's inappropriate, we would ask that it continue.
Well, I think the answer is it is inappropriate for this court to preserve anonymity without knowing why it's doing so. So it would be helpful if the parties were to supply us with written submissions in relation to that point.
Yes, my Lord, in that case we will put in written submission.
The court's grateful to counsel for their submissions and will take time to consider its decision.